Hold on. Are you ready? Okay. So our next case here is Stallworth versus State of Florida, number 2024-0584. Go ahead.
May it please the court, my name is Victor Holder. I represent the petitioner, Mr. Stallworth. I'd like to reserve 6 minutes for rebuttal, please. We're here because Mr. Stallworth was entitled to an instruction on the affirmative defense of duress at trial, and he was denied that instruction. He was entitled to the instruction because there was evidence to support the defense at the trial, and it was a valid defense to the charges of felony murder.
Would you kind of go through the evidence that supports the giving of the instruction?
Yes, and I think the most important, all of the evidence came through defendant's statements made in 3 separate interrogations with law enforcement that the state put into evidence at the trial. And so the most important, probably the two most important statements that Mr. Stallworth made come from page 387 and 388 of the transcript. And the most important is he says, if I had turned around, meaning if I had not continued with the robbery, continued to the shed with the robbery, if I had turned around, y'all would have 3 bodies right now, meaning him and his girlfriend who was the driver of the car. So again, his body, the girlfriend's body, in addition to the deceased. So right there, he's expressing his fear that if he didn't go forward with the robbery attempt, or the robbery, that he would have been killed and his girlfriend would have been killed. So
the evidence is the subjective understanding that Wild Bill is a dangerous person and would have killed him. Not, for example, an actual present, objectively observable thing like I'm holding a gun to your head.
Correct. It's Mr. Stallworth's belief, based on the circumstances he's in and his experience with, I believe it's Miles was the co-defendant. Wild Bill was another name mentioned, but I think Miles is the one that he's speaking of.
He's afraid of Miles.
Yes, and so he believes Miles will kill him. He states that. And then there's other statements that he makes during the interrogations that inform the reasonableness of that belief. He's been with Miles before. He's seen Miles get very aggressive and violent when he's high on drugs. Miles was high on drugs that night. He's seen Miles hurt people. That evening, he could see that Miles was serious based on his demeanor and look on his face. Miles was armed. According to Mr. Stallworth, Mr. Stallworth was not armed, and we must remember that we take the evidence in the light most favorable to the defendant when we're analyzing whether or not they get the defense instruction. He was outnumbered by the other two, by Grice and Miles, as far as co-defendants go.
I had to come up with a theme for the defense here. It would be perception is reality.
Correct. And
but let me ask you this. I mean, at the very beginning, when they got there, your client observed this person pistol whip somebody, and then he told him to put on the ski masks. Your client apparently was a bit hesitant, and he looked at him and said, I'm not kidding about the ski masks. And your client, I believe, testified, he gave him that look that only he could really understand what it meant. And that's, to me, that's the one crucial, from my perspective, one crucial factor that I think the first DCA left out, their opinion. And that's where it began.
I agree with you. He hesitates to put the mask on, and he as you said, as your Honor said, the co-defendant states, "Man, I'm serious," and he's got the look on his face that Mr. Stallworth is in a position to interpret. He's right there in the circumstances, and just like a self-defense defense, we judge it based on the circumstances that the defendant is in, and then it's for the jury to determine whether or not it's a reasonable belief that
giving this instruction, just to step back for a second and look at this through the lens of first principles, whether to give this instruction is a matter of the trial court's discretion, right? We're reviewing for abuse of discretion.
We are reviewing for abuse of discretion, but it is long-standing Florida law that a trial judge's discretion is much more limited in this situation where a defendant is requesting a defense, a sole defense, if there's any evidence at all to support the defense, the trial court has to give it. The defendant is entitled to the defense. So it's a limited discretion.
Can you lay out what the test has been, sort of traditionally, notwithstanding how the first DCA explained it in your case, but what is the trial judge supposed to do?
The trial judge is supposed to do, according to many cases from all the different districts and from this court, that if there's any evidence at all to support the defense, then they're to give it. It doesn't matter if the evidence is weak. It doesn't matter if the evidence the evidence of the defense conflicts with all the other evidence from the rest of the case. It doesn't even matter if, and let's say as it is here, the evidence is based on the defendant's statements. It doesn't even matter if the defendant's statements conflict with other defendant's statements, with his own statements. If he's got problems with credibility, it doesn't matter. If he's,
so it's not really a case in which the trial judge is typically looking for credibility, weight, quality. They're looking for sufficiency only.
Correct. They are not supposed to. The trial court is not supposed to weigh the evidence when it's making a decision whether or not to give the defense instruction, and the appellate court is not supposed to weigh the evidence.
And what
as
in
well.
particular do you think the first DCA did that is different than that?
Well,
in their analysis, because we're here kind of on a conflict, that we're not here just because you think your client
correct,
they were wrong, but it's a conflict. And so what do you think that they did that conflicts with this particular long-standing body of law?
Well, I think the first district's opinion actually conflicts in three different ways. First, they require the danger facing Stallworth to be real. And they don't even allow for the alternate possibility, which Hall, the Supreme Court case, Hall says that a defendant can reasonably believe that he's facing imminent danger. The danger need not be actual.
So they're looking at the weight or the quality, the weight of the evidence.
Yes, and so then the second way that I think the first DCA's opinion conflicts is that it makes a statement that a defendant's self-serving statement alone that conflicts with the rest of the evidence will not sustain or will not be an abuse of discretion if they deny the defense based on that. But there's countless cases, and I cited to many of them in the reply brief, where just that happened, where the defense was based solely on statements made by the defendant, and the trial court didn't give it, and the appellate court said it's an abuse of discretion. Any evidence, all, including just statements that conflict with evidence, entitle you to the defense. And I think
the bottom line, I'm sorry, it was a third one.
The third way I think it conflicts is that the first district seems to require a direct threat or an overt threat from the co-defendant in order to justify the duress instruction. And the law does not require a direct threat or an overt threat. It requires danger, real imminent impending danger, or a defendant's reasonable belief in that danger. I think a good analog for the duress instruction is self-defense, because it relies on the perception of the defendant in the circumstances he's in. He has to perceive a threat and make a decision, and that decision is then, the reasonableness of that decision is then judged by the jury.
Go ahead. I'm sorry.
No, go ahead.
I think the bottom line is basically that it's a very low bar when it comes to allowing these defenses, instructing on these defenses. And the way I'm reading the first district's opinion, it just seems to me like they're looking at it like elements of a crime. And if the element is not there, then we grant a directed verdict, a judgment of acquittal. And here, you did not act, the buzzwords didn't come out that I was scared because he threatened me or whatever. That didn't come out, therefore, he didn't prove it, and it's excluded. So that's what I think the bottom line is.
Well, I agree with you. I think it is a pretty straightforward. I think it is a very low bar for the defense to get, for Mr. Stallworth to get the defense. And I think the first DCA weighed the evidence improperly.
So I apologize if this is a dumb question, but can you just help me from a rules of evidence perspective how this kind of uncross-examined? Because I understand the statements against interest thing and everything, but this business about, the prior history with Miles and all that stuff, I mean, how, being put in for the truth of the matter asserted, I mean, how does this, can you just help me just walk through how this is, how it's actual evidence?
This came in because the state put it into evidence. It wasn't Mr. Stallworth did not put it into evidence. The state introduced these recordings into evidence and published them for the jury. There was no issue as to their admissibility.
But what hearsay exception were they traveling under?
Well, statements against interest, I would assume, and then I would also assume that the state would put it in there for two other reasons: to prove the credibility, or for credibility purposes, because Mr. Stallworth makes conflicting statements within those different interrogations. And I'm also assuming that the state put it in there to prove that he was at the scene, because they did charge him with felony murder.
So this business, though, about Miles and their history and all that, I mean, so you guys don't have any obligation to, because that aspect of the interviews doesn't itself fit within any kind of hearsay exception. So how is that even properly under consideration?
Well, the state put it in evidence and nobody objected to it, number one. Number two, the entire conversation provides context for the statements. So as far as he's saying he's scared, that's why. If you're asking what obligation the defense attorney has to not put evidence or not put the statements in, I'm not sure.
Okay. Yeah,
I'm not sure why a defense attorney would want to not have those statements in.
It just seems like if you want to, this whole thing should be, I know that arguably you can't kind of separate it from the stuff that is subject to the hearsay exception, but I mean, a lot of this is really, I think part of what maybe was troubling to the first DCA is that it's just, there's no, there was no opportunity. The issue, the state's interest in this wasn't this Miles business and whatever, and that's not the relevance of it. And I don't think that they were introducing that part to get to the truth about how scary Miles was, obviously. Now it's kind of being used for a different purpose. It seems like if the defense wants to use it to establish all this other stuff, then it should have to be subject to cross-examination or subject to an exception, which it's not.
Well, I'm not sure why the state would be able to put something into evidence and argue one way, but then the defense would be prevented from arguing the evidence that's been admitted.
I guess it comes down to what it's for. You know what I'm saying? But anyway,
I understand.
Don't worry about it.
Once it's in, and that's the case that's brought. That's where we are.
Well, no, but I mean, statements get put in, and they are objectionable or not, depending on what purpose they're being used for. And so at the time that the state is putting it in, they're not being used for the purpose that you're using it. So maybe they should have raised this before. I was just trying to get my head straight on how some of this is even on the table, because it's inherently kind of not super credible, and obviously we have ways to kind of determine how credible it would have been, which would have been cross-examination, et cetera, et cetera. That didn't happen here. I was just curious about that.
And certainly the state is free to argue the credibility problems on closing to the jury once he gets the defense.
Well, and the state had other witnesses too.
Yes.
That were not entirely consistent with some of the things that the defendant is saying in these recordings. So, but the state puts on its case, okay, and you're here to simply about whether the defendant could have the jury instructed on a defense, which was like all he had.
That was his defense, and that was his sole defense. There was evidence to support it. It was a valid defense to his charges. That's where we're at.
What evidence supported the determination that Miles was going to direct violence towards him? So in other words, was the evidence just that Miles is a scary person, or was there evidence from which a jury can conclude that he was going to actually experience violence or danger other than Miles just being scary?
The evidence comes from the defendant's statements, which were put into evidence, and the original statement is, I feared him because there would be 3 bodies if I didn't go along with it, essentially, page 388. It's the other things that the defendant says in the statement that the jury can reasonably infer that Mr. Stallworth believed that he faced danger.
But you would say in this particular case, there's no, even assuming in the light most favorable to Mr. Stallworth, there's nothing that showed that Miles directly threatened him. He was just a violent person in general, was kind of the understanding. There wasn't like, oh, he's threatened me before, he's, told me if I didn't do this, he would kill me. There was nothing like that, which is often kind of what we would see in that type of thing.
Right, so he didn't verbally threaten him. That's accurate. But you don't need a direct or an overt or a verbal threat. And jumping quickly to self-defense, Mr. Stallworth has witnessed Miles be violent in the past. That's something that you can take into account when you're judging a self-defense case. Has that defendant seen the violence of the victim in a self-defense case before, and that informs his reasonableness, the reasonableness of his decision.
It's something a trial court can take into account, right? Like, that's part of the reason I go back to the standard here. I mean, there is evidence that Miles gave him a look, right? That's basically the best answer you have to Justice Grossan's question, is there really wasn't a direct threat, but he did give him a look, and now this sounds really like a determination a trial court should be making.
Should not be making.
My point is that this is, I think, a core illustration of why trial courts have discretion to give or not give instructions, and I'm having a hard time seeing how the decision not to give the instruction, having considered these things, was fanciful, arbitrary, or no trial court would reasonably give this instruction.
And that is the wider discretion standard. But in these cases, discretion is much more limited.
You're going to help me understand how those two things are true, because it is the case that this is an abuse of discretion standard. You're right that other cases have recognized that when there is this 6-part test, and that exists for a reason. In other words, we wouldn't have a need for that analysis if, as you suggest, the right answer was, if there's even a scintilla of evidence of threat, then the duress instruction must be made.
Well, first, the defendant has a constitutional right to present a defense.
Yes, but this is about a jury instruction.
Well, that is one of the reasons why the discretion is more limited, because if there's any evidence to support his defense, he has that right, a due process right, to present his defense to the jury. So that's one reason why there's a more limited discretion. And the 6-part test, which the 6-part test that came from the jury instructions has its own issues and has since been replaced with a new jury instruction that more accurately reflects the state of the duress law, and that more accurately tracks the language from Hall and the other cases that have discussed duress pre-jury instruction.
But the key thing about whatever the test is, in deciding whether to give the instruction, the judge doesn't have to go through and weigh it all and think whether he thinks it is a good defense. I mean, that is absolutely not what the judge does. Under our law, the judge has to decide whether there's something that would tend to support that defense. Isn't that correct?
That's absolutely correct.
And we've got a big body of case law. So that's the role of the judge. And so the discretion has to be understood within that circumscribed role that the judge plays, which is not to go through and decide to weigh the different parts of the test at all.
Absolutely.
Correct?
Absolutely. Is there evidence to support the defense? It's very similar to when the state faces a judgment of acquittal motion. If they've put forth a prima facie case, if there's any evidence at all, it goes to the jury. It's not a situation where they weigh the evidence there, where they say, oh, the credibility of the state witness was terrible, we're going to grant the judgment of acquittal. Even if the worst witness in the world, credibility-wise, gets up there and lays out the elements of the crime, it goes to the jury. The jury then makes the determination. So it's the same thing here with the defense. The trial court doesn't weigh the witness testimony, doesn't weigh the weight of the evidence. It just looks, is there evidence, and then it gives the instruction if there's evidence and it's a valid defense. And I would like to return quickly to the kind of the overt threat, overt act portion. In reading through the Gonzalez case, which I cited in the reply brief, in the Gonzalez concurring opinion, there's a case called Radler, R-A-D-L-E-R, 290 Southern 3rd 87. And that says that no overt act is required. Now, this is in the self-defense context, but again, very similar defenses. No overt act on the aggressor is required to get the defense. And the Radler case cites to Chavers, which is another first DCA case, where the circumstances surrounding the defendant, even if there's no overt act, the circumstances can all add up to he felt fear, reasonable fear.
Yeah, and overt is obviously not in the jury instructions. But there is, imminent and impending perceived harm, that sort of thing. So it does suggest something other than like some knowledge that this person has been violent.
No, yes, correct. It requires a real, impending, imminent danger or a reasonable belief that he faces real, impending, imminent danger. And
so when objectively reasonable?
Objectively reasonable,
right.
Yes.
And so I think the question is getting at the idea that you've got to kind of look at the evidence of what was going on that's kind of there that you can objectively evaluate. And the question is, does just an assertion that this person has been violent in the past, does that meet that test? Is that the wrong question to ask?
Well, I think the objective reasonableness, whether or not he was objectively reasonable in believing he faced this particular harm, is for the jury to decide. It's not for the trial court to weigh when deciding whether to give the defense. I think that's first and foremost. And I think...
So you're saying as a matter of law, someone's just past violence that's sufficient evidence to, because obviously the jury gets to decide whether I believe is this statement in the interview, do I believe that he was violent in the past, and then does that put me in reasonable fear? But are you saying that just as a matter of law that's enough?
No, I'm saying that his past violence is a factor that adds to the reasonableness of Mr. Stallworth's.
And here we have that factor
Yeah,
plus
what
big
else?
eyes.
I'm sorry?
We have that factor plus, he made big eyes at him, right? What else would there be other than that?
We had that factor, the prior history. He made big eyes, and he also was armed with firearms. Mr. Stallworth was not. He looked at him. He witnessed him pistol whip two other people who didn't act fast enough. He witnessed the violence. He's witnessed violence before. He knew that he was extremely aggressive and violent because he's on drugs that night. He was extremely high, according to the statements. So I think all of that adds up to evidence that informs the reasonableness of Mr. Stallworth's belief, which he says his belief. If I had turned around, you'd have two bodies right now, which is referring to him and his girlfriend. So he stated his belief.
That's the subjective part. You agree that there's an objective aspect to this?
I agree that's his subjective belief, and then those things that I've mentioned, the prior history, the drugs, all of that, it then is evidence of whether or not it's reasonable, and that is all, whether it's reasonable, whether it's objectively reasonable, is for the jury to decide after it gets instructed on his defense of duress. I think where the error was is the trial court improperly weighed the factors, and the first DCA did the same. I'll go ahead and reserve.
Okay, thank you.
Good morning, Mr. Chief Justice. Good morning, Your Honors. May it please the Court. My name is Charlie Lee. I work for the Attorney General's Office, and I represent the state of Florida in this case. Before I get into why Stallworth does not conflict with Hall, I'd like to talk about the objectiveness and the what Justice Curiel brought up. In this case, we had a subjective fear. Looking at the jury instructions, it talks about reasonableness. It talks about real harm. And courts should be allowed to look at the context of all the facts, not weigh the facts, certainly. But duress is not, the jury instruction makes clear, duress is not like self-defense at all. Self-defense is, we don't discourage citizens from defending themselves, but citizens do have a duty to abstain from committing robbery and to resist duress and to avoid it at all or avoid committing offenses at all cost. And that's why we have a jury instruction. And I noticed that this court's current jury instruction talks about what a defendant must do. There's a note there about a split between the Fifth Circuit and the First. But both the Fifth and First say the defendant has the burden of production to establish each element of the defense before the jury instruction is given. That wasn't done in this case. The subjective fear that Mr. Stallworth had, just because he's around a bad guy, and he never pointed to why Miles was that bad. Does
that mean that there was no evidence of duress?
None of each element. Under the jury instruction, it says that he has the burden of production for each element of duress. Now there's 8 in the current jury instructions, but even the 6 Mickel elements.
But isn't that for the jury to determine?
Not if the defendant does not establish each element. Some evidence. Court shouldn't weigh it. Court shouldn't decide whether it's good evidence or bad evidence. Court shouldn't decide whether it's conflicted with other evidence. And as one
And he's entitled to reasonable inferences from the evidence, correct?
Correct. To give it context, like Gailey's
With
like
the jury, he's entitled for the jury to so it doesn't all have to be direct. It can be inferential.
It can be. In this case, there really is no evidence. I mean, Mr. Stallworth.
Well, I understand you don't like his evidence that you put on, the state put on, but he does say things that indicated, that seemed to indicate that he was fearful. Now, it may be totally self-serving. It may be totally inconsistent with other evidence. That's a different question. But when he's talking about having 3 dead bodies, that indicates that at least he's saying something that indicates that he was fearful of being one of the dead bodies. I mean, in the context, you have to understand it that way, don't you?
I didn't understand it that way. Assuming that
who were the dead bodies?
At that point, I'm not sure he knew who was murdered in that case and not. I mean, everyone was shot. Everywhere in the drug shed was shot. But assuming it was it would have been the decedent, Mr. Stallworth.
But he was talking about more dead bodies than there were.
Correct, Your Honor. And I'm assuming, in the light most favorable to Mr. Stallworth, it was him, his girlfriend. He never articulated how that would happen or why that would happen.
Again, this is not, the standard here is not a rule based on the articulateness of a defendant, is it?
I think a defendant...
Or the articulateness of any particular witness.
I think a defendant needs to point to a statement or an act that would lead a reasonable person to believe that they had to commit the crime or avoid whatever harm that outweighed that crime.
Isn't the real question here? All right, so the 3 bodies comment. I guess the real question is, what is that evidence of? Okay, because I think in order for the state to prevail, that has to be evidence of something other than duress. Because if it's evidence of duress, our cases say he should get the instruction. So it seems to me that what you're really arguing is that statement is evidence of Stallworth's subjective fear, not of Miles's duress applied to him. Am I right about that?
That's precisely what my argument is. The 3 dead bodies comment might be his subjective fear. Let's say it is. Would a reasonable person believe that based on the context of the evidence? No. And reasonableness is the cornerstone of the jury instruction.
When you say a reasonable person believe, not believe the sincerity of the fear, but you're saying would a reasonable person, in light of the facts that are the evidence, would a reasonable person perceive duress?
No, a reasonable person would not feel that they had to commit the crime to avoid some imminent harm.
And so we're not really, but I think the question is, one part of this is what was what was Stallworth? Was he afraid? It seems like there's clearly the three bodies thing that you can check that box, but isn't part of the inquiry like what is the evidence of what was in front of him objectively, and what an objective reaction to that would be?
Correct, Your Honor. I think the lens always has to be objective.
Right, and so what
Reasonableness
is that?
can't be subjective.
Right, and so what is the evidence of that? I know you say there isn't, but like what is it that we're arguing about as to whether X, Y, and Z is objective evidence, or right?
I'm not sure I understand the question.
I think his question is your point that there's no objective evidence that would have put a reasonable person in fear, even if we stipulate that he was in fear.
That's correct, Your Honor. Even based on Mr. Stallworth's statements, and they changed, but we're not weighing them, so even Mr. Stallworth's best statements, in the light most favorable to Mr. Stallworth, would not put a reasonable person in fear, or would not meet all of the elements of Mickle for a duress defense. And I know that the statement the court made in Stallworth was that a defendant's self-serving assertion, which is not supported by any other evidence, will not support the reversal of a trial court's discretionary decision not to give the duress instruction. I know that sounds like the court is weighing in talking about the weakness of Mr. Stallworth's statements, maybe, but it's also talking about the strength of the court's discretion. And the court has a lot of discretion in these cases to decide whether objectively a reasonable person would act out of duress.
What is
the standard for determining whether a defense instruction will be given?
If a defendant gives some evidence,
just the general standard applied to this and other defenses. What is the standard?
My argument's not is duress is different. It should be a rare defense, not like self-defense, but even in a self-defense case, a defendant has to give some...
Is the standard different for duress than for... Is the standard of what is that applies to determine whether the defense should be given, is it different for duress than for other things?
There's a lot more elements to a duress defense.
Well, I understand that. I understand defenses are different, but isn't there a general standard about what a judge has to, the determination that the judge has to make in deciding whether a defense instruction should be given?
If there's any evidence that supports all the evidence.
Any evidence, right.
That supports all the elements. I mean, I don't think a defendant should get a duress defense just because he meets one or two elements of the jury instruction. That would just confuse the jury when duress hasn't been demonstrated, especially when the jury instruction says that the defendant has the burden of production. Now, the Fifth says once the defendant has met the burden of production, then the state has to overcome that. The First follows the common law, which says that the defendant still has to prove they still bear the burden of proving their affirmative defense. So it is a lot different than self-defense. And it should be a rare defense. It should be like entrapment. It's only in those rare cases, because citizens have a duty, like I said, to abstain from crimes, resist duress, and do whatever they can to get out of these situations. And not one of the elements is not put themselves in these situations, which could lead to this type of crime, which Mr. Stallworth, by his own admissions, did. So in this case, it cannot be said that the lower court abused its discretion by denying the jury instruction on duress.
Let me ask you about some of the statements the First DCA made, notwithstanding what the trial court did. They said, this court may not reweigh the evidence, meaning in their determination of whether the lower court had abused its discretion. What do you think they meant?
May not reweigh the evidence.
Yeah, there was, the lower court deemed there was insufficient evidence to support a duress instruction. This court may not reweigh the evidence. What do you think that means?
I think it means that the court cannot second guess the lower court's use of its discretion. I don't know that there's any evidence that the court weighed evidence. It simply found it applied the Mickle factor. I mean, it cited Mickle.
The lower court
cited Mickle and applied Mickle, and so I'm not sure what the DCA meant there. But
when you say that there's no evidence that the district court weighed the evidence, that baffles me. When the district court has specifically denigrated the evidence as self-serving, that's weighing it. That seems to me, I don't know how you escape that.
I was speaking about the lower court. There's no evidence at the lower court.
I'm sorry, I missed the thread there.
The lower court religiously applied Mickle and cited Mickle and went through the factors and decided that Mr. Stallworth was not entitled to the jury instruction on duress. Stallworth, it has some language that lacks clarity, to be
well, it seems pretty clear.
Well,
I think it's clearly erroneous.
I think,
or at least clearly in conflict with a vast body of case law.
The result isn't. If we look at what the trial court did in applying Mickle and what the facts are, there's no instance where Mr. Stallworth would have been entitled to a duress instruction. And it wasn't his only defense. In his closing argument, he simply downplayed his involvement, which he did during his statements anyway. So it may be a harmless error if it's an error at all. But despite the language in Stallworth that's problematic, I don't think it conflicts with Hall, which is the stated conflict. That talks about a harm that's existent at the time, where this is whether being in the presence of a person that's you perceive subjectively to be dangerous is a reason to get the duress defense, and it shouldn't be. They should be able,
Well, but there is some objective evidence that this person was dangerous, isn't there?
I don't see any direct evidence that, that he committed the robbery, but
a most brutal sequence of events.
But Mr. Stallworth was already part of the crime when the violence there had started. He says that he got into the crime because, he saw that there was masks and there were guns, and his quote was, I told myself, I'm not misquoting him, but in my own words, he said, I told myself, do what you can. And he went along with the robbery. But he never pointed to, Mr. Miles obviously never pointed a gun at him. Mr. Miles, by Mr. Stallworth's own admission, they hung out all day. At one point, Mr. Miles was Mr. Stallworth's cousin. Another point, he wasn't. I guess we go with it. He wasn't in the light most favorable Mr. Stallworth. But if this is going to be a case, that I guess the closest analogy would be a mob boss that, some might make indirect threats. Do you have a chance to go to the police? Do you have a chance to avoid this? These are all things that the defendant has to establish. And if they don't get the jury instruction. In this case,
was there evidence that he participated in the planning?
Oh, there was. His girlfriend, if we were weighing evidence, not suggesting that we would, his girlfriend's testimony, completely. And had he gotten the duress defense, I think his girlfriend's testimony would overcome that defense, because she says he was with a mask, with a gun, goes to the robbery, comes back with, they all came back with more guns than they had initially. Also, 3 types of guns were fired on the scene. Her testimony, 3 men took 3 guns to the scene. But getting out of, weighing the testimony, he didn't establish he didn't meet his burden of production for each element of the jury instruction. And so in the end, the trial court did not abuse its discretion in denying him the duress instruction. And so the result in Stallworth was the correct result, and I'd ask this court to affirm Stallworth and state that I would ask this court to decline jurisdiction, enter an order dismissing jurisdiction, because nothing in Stallworth conflicts with the language in Hall, and in the alternative, affirm Stallworth because the district court reached the right result. Thank you, Your Honors.
Thank you.
So Mr. Stallworth was entitled to the defense instruction based on the evidence at trial, and he's also entitled to all the reasonable inferences that are drawn from that evidence. And reasonable inferences based on the totality of the circumstances he was facing is that he feared this Miles and the other co-defendant, and that he feared if he did not go along with the robbery that they would kill him or kill his girlfriend.
What is the evidence that that Miles applied duress?
The only overt evidence is the look that he gave, as Justice Labarga mentioned, the look that
And
he...
how does the look come into that is Stallworth's statement, right? Or is there any other evidence of the look?
Stallworth statement. They are originally going to... Stallworth thinks they're going to the shed to buy drugs. It's a trap house. It's a place where drugs are sold. And as they are getting out and approaching the shed, the co-defendants produce masks and guns. And when Stallworth is hesitant, is taken aback and hesitant at this production of masks and guns, that's when Miles gives him the look that he interprets as that this is serious and that I'm going to be in trouble if I don't go along with this.
And he tells him to put the mask on.
And he orders him to put the mask on. And he says some language that I'm not going to repeat, but it's not polite language. And he orders him to put the mask on. That's correct. I'm sorry?
Is it a threat?
It's not an overt threat and a classical I'm going to kill you if you don't do it type of way, but it's certainly, I think that he could interpret it that way. He knows the man, he's in the circumstance, and he obviously interpreted it as a threat. And whether or not that interpretation is reasonable is for the jury to decide after it gets the duress instruction.
But to be clear about this, duress does not require a threat, correct?
That's absolutely correct.
Is the word threat even in the instruction?
The instruction...
Or I don't know. I'm not sure I'm looking at the right version of it. But it's basically about danger or emergency.
The Hall court uses the word danger, and then the old version of the jury instruction says danger or emergency that threatens significant harm. So threatened harm is what the old version say. The new version of the jury instruction again calls it a danger that would cause death or serious bodily harm, the perceived harm or of death or serious bodily injury.
That was imminent and impending.
Yes. And so whether his fear is objectively reasonable is a question for the jury. And there's no requirement of an overt threat, specific words, I'm going to kill you if you don't do this. He has to believe, and then his belief has to be reasonable, that he's facing this harm, this imminent, immediate, real harm.
But the court, in deciding whether to give the instruction, does not have to decide that it is reasonable.
I agree. No, he does not. He just has to...
But that's not just that you agree. Isn't that clear in our law?
Yes. It's just check, as you said, check the box. There's evidence that's been admitted. Check the box. Give it to the jury. Give the instruction to the jury. The jury decides the reasonableness.
No, but the judge doesn't have to decide whether the evidence that's put in is such that if it's believed, it would constitute as a matter of law evidence that's objectively meets the objectively reasonable threshold.
The case law, case after case after case, says it does not matter if the trial court finds the evidence to be weak or improbable.
Right, I know, that's not what I'm saying.
Then
I'm saying if I believe everything you say, if I believe that you gave me, that the guy gave Stallworth a look, right? Would that be evidence that could lead an objectively reasonable person in Stallworth's position to be under duress? That's the question, I think. Not did he give them the look or whatever, but if that's true, would that satisfy the objective test to put a reasonable person in fear under all the circumstances?
Well, and again, I think that's for the jury to decide whether his belief was reasonable.
Okay, but that's okay. I don't think that the objectively reasonable thing, that's a question of law. That's not, the jury's job is to find out who did what and whatever, but for us to say, we can say as a matter of law that such and such is within that zone or it's not.
I think that constitutes the trial court weighing the evidence.
Okay. I disagree with you, but no disrespect.
I understand, absolutely no disrespect.
No, I know, of course.
As far as the first DCA mentioning reweighing the evidence, I think it's almost a Freudian slip that the trial court did weigh the evidence. It's clear the trial court was looking for an overt act. It didn't get it, and it didn't want to use the self-serving statements that Mr. Stallworth gave, and admittedly self-serving. But what defense statements and in police interrogations, many of them are self-serving, and they're still evidence, and they still can be relied on to get a defense instruction. There's multiple cases that give the self-defense instruction based on just self-serving statements in police interrogations. With that, I would conclude and ask the court to order a new trial on the felony murder, and then based on issues on the other issues that I raised in the brief that we haven't discussed today, is not allow retrial on the aggravated battery and the the premeditated murder. Thank you.
It's all a package.
I'm sorry?
It's all a package. Thank you.
All right.